Hello, everyone. Welcome back to our daily issue analysis (DIA). And today we are back with another issue, very important issue from the current affairs. So let's start for the day and see what is the topic. So today we have taken this topic of anti-defection law, and we know why it is in news. So as you can see, this person, Eknath Shinde, he belongs to the ruling party of Maharashtra, and Eknath Shinde, and along with him, there are 15 members who have decided to come out of this party, and because of which it is going to create a political crisis in Maharashtra. And not only that, it has also brought the focus back to anti defection law. So, with respect to that, it is in news. Supreme Court has also taken some decision, and the issue is going on in court. The issue is there. The whole debate about into anti defection law is ongoing in media. That's why we have taken this in news today, and we will see further. So it's not that anti-defection is happening for the first time in India, and it is there in the political landscape from last 5 decades. And as you can see, this person, along with Indira Gandhi, he was then in 1967 he was Haryana's independent MLA Gaya Lal. So there is a very famous phrase "Aya Ram Gaya Ram," because of which he is popular. So the story is that he changed parties 3 times within the span of 15 days in 1967, affecting the stability of the government. Okay, so it became popular. This anti-defection, the issue was brought to limelight because of this Haryana independent MLA Gayalal. Okay, and it led to instability of the governments who were surviving on threadbare majority. So horse trading tendencies, or the ayaram gayaram phrase, it became very common in those days. Okay, so this was there, and it affected the major government and converted in them into minority government. The stability was affected. So the first step towards cleaning up public life was seen by Rajiv Gandhi, the then prime minister. He thought that okay, there has to be anti-defection law, and then they brought anti-defection law under 52nd Amendment Act in 1985, and because of which under 10th schedule the anti-defection laws were included in the constitution as the 10th schedule. Okay, so this and these anti-defection laws, they were called as the first step towards cleaning up the public life. So this is the story that how anti-defection started in India from because of this MLA Gayalal, and then how we came up with our anti-defection law under 10th schedule of the Constitution, 52nd Amendment Act, 1985. So we should remember these facts because these facts are very important whenever we are introducing any question on anti-defection. If not prelims, it is very important for mains also, because for introduction we need to have these facts. Okay, so this is about anti-defection law. Now we'll see other aspects related to it. The anti-defection law, which was introduced, it analyzed the grounds for disqualification, which is even true for today. All the anti-defection which is happening is emancipating from all these three scenarios. So the first scenario is giving up party membership, the second being going against party whip, and the third being abstaining from voting against. Let's say if party has decided something to vote upon and we are abstaining from voting as per the party's wishes. So whatever anti-defection problems are emerging, they fall under these three categories. Because of these three things only they are happening. So let's understand the issue in detail. Now we will discuss about the issues in the anti-defection law. So starting with the first issue, that is the whole anti-defection law is against representative democracy. Why? Because just imagine that we as people, we as citizens, we choose our representatives based on the kind of people they are, their ideology, the ideas they support, their view about the development of an area, or their view, their opinion about certain issues. So we select them, we elect them. So basically, when these people, our representatives, they get elected and they join the party. So after that, they start following the MPs or MLA elected. They are there to represent people's view, but they start following what party is saying, party's opinion, party's stand. So basically, it is the mockery of people's mandate. For example, it happened during Telangana and Andhra Pradesh division time. that many people elected their MPs and their MLAs based on what kind of ideology they have with respect to separation and unification. So there were instances when people supported any particular MLA, that okay, this person, we know that this person supports the cause of separate Telangana and separate Andhra Pradesh. But when they got elected and they had to take a choice, they had to represent people's view. So they were not they were acting against representative democracy. They were taking a stand on unification, and they were taking again this stand because their party wanted to do so, because if they will not follow what their party whip is saying, they will be disqualified. So this is against representative democracy. So this is the first one, and it is against people's mandate. The second issue is that it weakens the accountability. What happens generally, the representatives, according to the constitution, we elect our representative, we the people of India. But these representatives, in spite of being accountable to constitution, ultimately to people, they show their accountability to the party. So it is weakening the whole idea of accountability, because legislators are becoming accountability to party. What party is saying, they have to do that. What party is saying, they have to speak that much only. So they lose their independence of putting any ideas or any aspect of independence, and thus it is weakening the accountability, because they are not no more accountable to the people who have elected them. The third issue is with respect to that it weakens the deliberate democracy. So what happens that, let's say if I have my independent opinion as an MP or MLA, and if I have to represent my people's view, my people's concern, it might happen that on certain issues I will have different opinion. It means whenever any discussion or debate or any introduction or any policy reforms or policy choices are being made, I will put my ideas. I will. It might happen that I will take a stand against my party's decision or my party's overall stand. But in this case, because of anti-defection law, you cannot do so. So it is weakening the deliberate democracy. Thus, there is no incentive on the MPs or MLAs to discuss, think, ponder, deliberate, or come up with other choices or analyze the other outcomes. They're not doing so because they know that ultimately they are supposed to do that only what their party whip will say, or the party will ask us to take this stand. We have to take that only. We cannot abstain from voting. We cannot take a stand against our party's stand. So this anti-defection law is actually weakening the deliberative democracy. The fourth issue is that it is against the freedom of speech and expression provided in Article 19, because you don't have your own freedom of speech and expression. You can't express your views, your stand clearly, openly, because you are bound by the party whip. So this whole anti-defection law is ultimately undermining the constitutional morality or the constitutional values, because of which the representative aspect of democracy is being mocked upon. It is mockery ho raha hai uska. Okay? So let's understand other issues. Other issues we will discuss is one related with powerful presiding officer. This is our fifth point. So this whole anti-defection law, in this law, presiding officer is very powerful. The speaker, be it in case of legislative assembly or in case of our Lok Sabha. So a speaker decides the disqualification, be it how to resolve the issue, making rules, or uh, which person or which MP or MLA should be disqualified. All the decisions, even of making rules related to defection, all the decisions are taken by the speaker itself. So they are very powerful. In fact, earlier a speaker's decision was not even challenged, but later it was found that the decisions were happening based on the political gains and not political neutrality. There was no political neutrality. So Supreme Court decided in Kyoto Holon versus Zachilu case, and they told that when a speaker is exercising this power of deciding disqualification on ground of defection, he is essentially acting like a tribunal. Therefore, whatever decision a speaker takes, it is subject to judicial review. So what happened after that? If somebody is getting disqualified based on defection, so they can go to Supreme Court if they are not satisfied, and then court can accept such cases as well. Okay. But here the catch is, what if a speaker sits over disqualification petition? So here anti-defection law is not mentioning any time limit to decide on such cases. So a speaker has more power than it is required, and there is no accountability on time limit to speaker to decide such cases. So thus it is a speaker here, which the presiding officer has a lot of power with respect to this, which is not good. Also, with respect to second aspect, the sixth point, the issue is there is no disqualification based on resignation. So if you remember, three grounds which we discussed with respect to disqualification of MLAs, the first one was giving up party membership. Second one was going against party whip. And the third one was abstaining from voting. So here, whenever we talk about giving up membership, party membership, it is not mentioning about resignation. Yes, the whole anti-defection law, there is no mention of word resignation. So if we talk about giving up party membership, it is more about not behaving as per the wishes of party, not attending the meetings, and that is how it is concluded, and it is found that the person is no longer loyal to the party. But our law, the anti-defection law, is not mentioning a word about resignation. So if I resign, then I do not fall under the category of, or the it will be not counted as defection. So no disqualification based on resignation will happen. So a few years back, like 1 or 2 years back, somewhere around 2020, there were 17 Karnataka MLAs. They resigned, and and thus they exploited this loophole and they resigned. And this act, the overall objective was it ended the majority of the ruling coalition. At the same time, it avoided disqualification, so it was a win-win situation. So we need to bring amendment where we need to add resignation as a ground for disqualification also. So this is another issue. Next, taking the path of re-election. So when anti-defection law in 1985 was introduced, so at that time, yes, if individual member is going, it is disqualification. But they accepted a split within party. If one third member are going out, and then it will be considered as uh, a split within a party. But it was believed like, okay, so such cases will happen. How to put a check on this? So 91st Constitutional Amendment Act, that is in 2003. Remember it, 91st Constitutional Amendment Act in 2003 deleted this provision of allowing a split. So it told no, even that will be considered as disqualification. So 91st Amendment also barred the appointment of defectors. The 91st Amendment Act, they come up with another clause. They also barred the appointment of such defectors as ministers until their disqualification period is over or they are re-elected. Remember it. So there is a catch. Two provisions were there, that these defectors will be barred for the appointment as minister until their disqualification period is over. Let's say for only three years are left, so disqualification period is over, or they are re-elected, whichever is earlier. So again, a new loophole was created, and these Karnataka's MLA 17 who resigned, they defected. Let's say, so they got re-elected. 11 of those people, they got re-elected, and so they made use of this loophole. 11 of them got re-elected to another party. So this is another issue, taking the path of re-election. Next, buying MLAs for paid rest. So this is happening. So SY Qureshi suggested, he explained that how defecting MLAs need to be barred for at least 6 years before they can contest election again, so that they will be barred from the next general election as well. But if it is done, it is also not going to solve the problem, because MLAs can still be bought from the ruling dispensation. So if some party is having money, they can go to the leaders of the representatives of other party and they can buy them. They can tell them that, okay, you take this much money and you take rest for 6 years. You don't worry. And the opposition party, they will go to minority. So thus, by paying hefty sums simply to stay at home or 6 years, the MLS can be bought. So that is also not a solution that we should what SY Qureshi suggested, that how defecting MLAs should be barred. So that is also not a solution. So these are the issues. Now we'll see other aspects of anti-defection law. So there are two important judgments. One which we have already discussed, Kyoto Holan. Okay, so here we discussed, in this case, Supreme Court decided that whenever a speaker is taking such decisions and he is essentially acting like a tribunal. So therefore, whatever decision a speaker is taking is subject to judicial review. So MPs, MLAs, they can go to Supreme Court if they are not satisfied. So this is very important case. Next is another case, which is Rajendra Singh Rana versus Swami Prasad Maurya case. So it was there in 2007. Supreme Court stated that if, so we have already discussed a loophole, that if what if speaker is sitting and there is no time limit, if they are sitting over the file and they are not taking a decision. So Supreme Court in 2007 told that if a speaker fails to act on complaints, or if they are unable to take any action, if they are not taking any action, so basically they are failing to perform their duty as per 10th schedule of the Constitution. So Supreme Court is saying that then they are essentially violating their constitutional duties which they are supposed to do. Okay, even though Constitution is not giving any time limit, but they are violating their duty. So these are the two important cases related to anti-defection. Okay, next we'll see important committees. Now there are two important committees. The first one being Dinesh Goswami Committee 1990. So we have already seen that the members, the representatives, the MLAs, the MLAs or MPs, they need to act according to the guidelines given by the whip. If they are not doing so, they will be disqualified. Right? We have seen that it is a ground for disqualification. So Dinesh Goswami Committee in 1990 recommended that restrict this disqualification for voting against whip only in cases like important matters like no confidence motion is there. Okay, and rest of the time let the representative, be it MLA, MP or MLA, come prepared, and they have also their own freedom of expression. Let them express their views so that they can participate in debates, discussions, deliberations. Okay, so this way their freedom of expression will be also maintained. And even LC, that is Law Commission, also maintained the same view. Next we have is Constitutional Review Committee, Venkat Chalaiya Committee. Okay, so they also, this committee recommended that the defectors should be barred from holding any public office or any other political position for the remainder of their tenure. But what is happening in this case? Even if they are defector, they are coming back to the same office. So there is no disincentive for them. So, like they are not being punished. So Venkat Chalaiya Committee recommended that debar them from holding any public office or any other public position. Okay. So this is about committees. Now we'll see the way forward. Now let's discuss about the way forward. So conclusion, in conclusion, you should write that we should strengthen the party system. At present, the internal party system, they don't ensure greater exit barriers. So for example, even if we join company, we have to sign a contract that minimum you have to serve for 2 years, 3 years. There should be exit barriers so that the loyalty towards party should be maintained. So exit barriers should be strengthened. Then we have already discussed about Venkat Chalaiya Committee. We have discussed about our Law Commission. So they recommended about that defectors should be barred from holding public office, and Law Commission also recommended, like Dinesh Goswami Committee, that only with respect to matter of no confidence motion and important issues, voting against whip, restrict this disqualification for voting against whip only to such cases. Also, we need to amend the laws to tackle the loopholes which we have discussed about the speaker sitting over without any time limit, and resignation is not covered, re-election should not be allowed. So these, whatever we have discussed, take the help of that and put it as a way forward, that what all needs to be reformed. So with this we end the topic of anti-defection. Hope it give you clarity about what is happening around, and in future you will get further clarity about when as and when the issue will be in the news. Okay, so take care guys, and see you in the next video. Bye bye.